Ivanka Trump just received a federal subpoena that changes everything. A sitting federal judge has given her exactly 10 days to appear for testimony in what legal experts are calling the most significant development in the Trump Organization criminal investigation since the original indictments. And this isn't some routine legal maneuver or standard discovery request. This is a direct judicial order sparked by newly uncovered evidence so damning that prosecutors convinced Judge Arthur Engoron to bypass normal procedural delays. When federal judges start compelling testimony from former first daughters under threat of immediate arrest, something catastrophic has just rocked the Manhattan District Attorney's Office. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what set off this unprecedented judicial intervention? A leaked internal memo from the Trump Organization's accounting firm allegedly details Ivanka's direct involvement in fraudulent property valuations while she served as executive vice president. Sources reviewing the document claim it contains her personal signature on at least 12 separate instances of inflated asset appraisals used to secure favorable loan terms. This isn't just another political controversy or family drama spillover. Members of her own legal team are reportedly advising immediate cooperation to avoid criminal contempt charges. And believe me, when federal judges issue 10-day compliance deadlines with explicit arrest warrants attached, something enormous has just detonated. Here's the full picture of what's been unfolding. Tensions between the Trump Organization and Manhattan prosecutors have been escalating for months, fueled by document production battles, executive privilege claims, and repeated conflicts with court-ordered compliance deadlines. The investigation initially focused on general business practices, but prosecutors gradually narrowed their scope to specific financial transactions involving inflated asset valuations used to secure favorable lending terms. The breakthrough came during what sources describe as a routine review of documents provided by Mazars USA, the Trump Organization's former accounting firm. According to legal sources familiar with the discovery process, Mazars had been cooperating with prosecutors since October 2024, providing thousands of pages of internal communications, property assessments, and financial projections spanning from 2014 to 2021. But everything escalated according to multiple sources on January 15th when a confidential accounting memo surfaced during this routine discovery, showing what prosecutors describe as a systematic pattern of financial fraud spanning nearly a decade. The document, previously protected by attorney-client privilege claims that were recently overruled by Judge Engoron, allegedly provides the smoking gun evidence that prosecutors have been seeking since the investigation began. The memo, dated from December 2019, reportedly documents specific instructions from Ivanka Trump to inflate property valuations at Trump Tower Chicago, Trump International Hotel Washington, and Mar-a-Lago by amounts exceeding $40 million. Sources familiar with the document say it includes detailed calculations showing the difference between internal Trump Organization valuations and the inflated figures provided to Deutsche Bank and other financial institutions. This wasn't about aggressive accounting practices or legitimate business strategy disputes. It was about what the district attorney's office characterizes as deliberate criminal fraud designed to mislead financial institutions. The memo allegedly includes explicit acknowledgement that the inflated valuations were inconsistent with market assessments, with handwritten notes indicating awareness that the figures were false. Smash that like button if this is making sense so far. Here's where it really gets serious. When prosecutors presented the memo to Judge Engoron in a sealed hearing on January 16th, legal observers say his reaction was immediate and unprecedented. Court staff described the judge as visibly agitated after reviewing the evidence, leading to his extraordinary decision to issue the emergency subpoena with such an accelerated timeline. And let's be honest for a moment. 10-day federal subpoenas with arrest warrant provisions are extremely rare. They don't happen over civil violations or routine document disputes. They happen when prosecutors convince a sitting judge that criminal activity is both clear and ongoing. Here's what multiple sources say happened next. On January 17th, a team of federal marshals personally served the subpoena at Ivanka Trump's Miami residence at approximately 7:30 a.m. Eastern Time. Witnesses described a convoy of 3 black SUVs arriving at the Star Island property, with agents spending nearly 2 hours inside the residence. Sources told CNN that Ivanka's private security initially attempted to delay the service, claiming she was not available for legal documents. The tension escalated dramatically when the lead marshal, identified by sources as Deputy Marshal James Rodriguez, reportedly informed security personnel that obstruction of federal service carries its own criminal penalties, distinct from the underlying investigation. Rodriguez, a 20-year veteran of the Marshal Service who typically handles high-profile fugitive cases, was specifically selected for this assignment due to his experience with uncooperative subjects from wealthy families. According to neighbors who spoke anonymously to local Miami media, the Marshal convoy attracted significant attention on the normally quiet Star Island enclave. Security cameras from adjacent properties allegedly captured the entire 2-hour standoff, with Ivanka's security team making repeated phone calls to legal representatives while federal agents waited patiently outside the main residence. The situation became increasingly tense when additional Marshal backup arrived at approximately 8:15 a.m., bringing the total federal presence to 12 agents. Sources familiar with federal service protocols say this level of backup is typically reserved for situations where authorities anticipate resistance or potential flight risk. By 9:45 a.m., Ivanka Trump had personally accepted the subpoena, along with what sources describe as a detailed evidence packet running more than 200 pages. Witnesses say she appeared visibly shaken during the brief exchange with Marshal Rodriguez, asking repeatedly about the timeline for compliance and whether she could request an extension through her attorneys. The subpoena itself demands her appearance before the grand jury on January 27th at 10 a.m., with specific testimony required regarding her knowledge of property valuation processes, communications with Deutsche Bank representatives, and her role in securing the $125 million credit facility that prosecutors now claim was obtained through fraudulent representations. Legal experts note that the specificity of these demands suggests prosecutors have already developed substantial evidence and are seeking testimony to fill specific gaps in their case. Court documents filed immediately after the service reveal additional troubling details. The subpoena includes a comprehensive evidence preservation order, requiring Ivanka Trump and her representatives to maintain all documents, electronic communications, and recordings related to Trump Organization property valuations from 2014 through 2021. Violation of this preservation order would constitute additional federal obstruction charges, carrying potential sentences of up to 5 years in prison. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. According to court documents filed under seal but obtained by multiple outlets, the accounting memo contains detailed handwritten notes in what experts have confirmed is Ivanka's distinctive handwriting. The notes allegedly include specific instructions to maximize Chicago projections and ensure DC values support the refi terms we discussed. Handwriting analysis commissioned by prosecutors and conducted by Dr. Margaret Stevens, a certified forensic document examiner with 30 years of federal court experience, reportedly concluded with 97% certainty that the handwritten annotations match known samples of Ivanka Trump's writing from business contracts and White House documents. Dr. Stevens, who previously provided expert testimony in major white-collar cases, including the Enron prosecution, told investigators that the handwriting exhibits distinctive characteristics that make identification virtually certain. The bombshell moment came when prosecutors revealed during their sealed presentation that the memo includes a previously unknown recording reference. Legal sources familiar with the evidence say Ivanka apparently made audio recordings of her conversations with accounting staff, believing they would serve as protection against future liability. Instead, prosecutors claim these recordings provide direct evidence of criminal intent. Sources who have reviewed transcripts of these recordings describe them as devastating to any potential defense strategy. The recordings allegedly capture Ivanka Trump explicitly acknowledging that property valuations provided to banks differed substantially from internal assessments, with her voice clearly stating, "We know these numbers are optimistic, but that's what they need to see to get comfortable with the terms." Additional recordings allegedly document conversations with Deutsche Bank relationship managers, where Ivanka provided specific property valuations while acknowledging privately that the figures were best-case scenarios, designed to maximize our borrowing capacity. Federal prosecutors specializing in white-collar crimes say this type of recorded evidence of intent is extremely rare and typically results in guilty pleas rather than Trial proceedings. Manhattan District Attorney Alvin Bragg's office released a carefully worded statement confirming the subpoena while declining to detail specific evidence. But the statement included language that sent shockwaves through legal circles. Recent developments have provided compelling evidence of criminal conduct requiring immediate grand jury testimony to prevent ongoing harm to financial institutions. The phrase ongoing harm has particular significance in federal fraud prosecutions. Legal experts explain that it suggests prosecutors believe the fraudulent activity either continued recently or that failure to address it immediately could result in additional financial institutions being deceived. This language is typically reserved for cases where prosecutors seek to prevent imminent criminal activity. When prosecutors use phrases like compelling evidence and ongoing harm, it signals one thing. The evidence has moved beyond circumstantial or technical violations into what they believe constitutes clear criminal activity. This isn't the first time a Trump family member has faced federal subpoena power. Think back to Donald Trump Jr.'s testimony before the Senate Intelligence Committee in 2017, where he faced questions about Russian contacts, but ultimately avoided criminal charges. The key difference was that investigation focused on political activities rather than business fraud. Then there was Eric Trump's deposition in the New York Attorney General's civil investigation, where he invoked Fifth Amendment protections more than 500 times. While politically damaging, civil depositions carry no immediate arrest authority if witnesses refuse to appear. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the pattern that emerged during Ivanka's congressional testimony regarding January 6th. Where she carefully distanced herself from her father's most controversial decisions while maintaining she had limited knowledge of operational details. Legal experts noted her testimony seemed meticulously prepared to avoid creating criminal liability. Now, however, it's different. This time, prosecutors have what they claim is direct documentary evidence bearing her signature and voice. The pattern is clear. When federal prosecutors move from investigating potential crimes to compelling testimony under threat of arrest, even family loyalty has constitutional limits. So, what allegedly triggered this unprecedented judicial intervention? According to white-collar crime experts who specialize in financial fraud cases, the evidence prosecutors presented to Judge Engoron likely met the imminent criminal activity standard required for emergency subpoena procedures. The memo reportedly shows direct communication between Ivanka Trump and Deutsche Bank relationship managers regarding property valuations, with her allegedly providing specific inflated figures that prosecutors claim she knew were false. These weren't routine business projections or optimistic estimates. Legal experts describe them as what could constitute federal wire fraud if prosecutors can prove intent to deceive. Here's the kicker. The memo reportedly includes explicit acknowledgement that the valuations differed substantially from internal Trump Organization assessments, with Ivanka allegedly writing external numbers only next to several property values. This wasn't inadvertent overstatement or aggressive marketing. It was, according to prosecutors, deliberate misrepresentation designed to obtain financial benefits she wasn't entitled to receive. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone. This isn't just about one accounting memo or one family business. If the evidence proves that Ivanka Trump knowingly participated in systematic financial fraud while serving in the White House, it raises unprecedented questions about conflicts of interest, abuse of position, and the intersection of personal business interests with official government duties. Once that precedent is established, there's no turning back from the reality that even family members of presidents are subject to criminal accountability. This puts Ivanka Trump in a nearly impossible position. On one side, she faces intense family pressure to protect Donald Trump from additional criminal exposure, particularly if her testimony could implicate him in the broader fraud scheme. That means invoking Fifth Amendment protections or claiming attorney-client privilege wherever possible. On the other side, she's forced to reckon with what legal experts describe as overwhelming documentary evidence that already places her at the center of potential criminal activity. She now has to explain to federal prosecutors why her signature appears on documents that allegedly contain information she knew was false. And here's the tricky part. There's no credible legal defense. Either the memo and recordings are authentic, in which case her direct involvement in financial fraud becomes difficult to deny, or they're fabricated, which would require believing that multiple federal agencies, accounting firms, and financial institutions collaborated to manufacture evidence against someone who was largely absent from political controversy since leaving the White House. Legal and political analysts are calling this a constitutional crisis unfolding within the Trump family's business empire. Barbara McQuaid, former federal prosecutor and current University of Michigan law professor, told MSNBC that if the evidence is as substantial as prosecutors suggest, Ivanka Trump faces serious federal charges that could include wire fraud, bank fraud, and conspiracy. She emphasized that financial crimes of this magnitude typically carry sentences ranging from 5 to 20 years in federal prison. Additional legal experts have weighed in with similar assessments. Andrew Weissman, former federal prosecutor who served on Robert Mueller's special counsel team, told CNN that the combination of documentary evidence and recorded conversations represents the kind of proof that white-collar prosecutors dream about. He noted that financial fraud cases typically rely on circumstantial evidence and witness testimony, making direct documentation of criminal intent extraordinarily valuable for securing convictions. The recordings mentioned in the memo could prove particularly damaging. Glenn Kirshner, former federal prosecutor and legal analyst, explained to MSNBC viewers that audio evidence of criminal intent is often decisive in white-collar cases because it eliminates the defense that misconduct was inadvertent or based on legitimate business judgment. If prosecutors have recordings of Ivanka Trump explicitly acknowledging that property valuations were inflated for fraudulent purposes, conviction becomes significantly more likely. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Jonathan Turley, a conservative legal scholar who frequently defended Trump during both impeachment proceedings, acknowledged that the allegations are extraordinarily serious. He told Fox News that while presidents have wide discretion in business matters conducted before taking office, using fraudulent documentation to obtain financial benefits crosses clear legal boundaries that should concern everyone regardless of party affiliation. Turley specifically noted that financial fraud lacks the political immunity that might protect other presidential activities. So, let's break down what this could mean. First, the immediate legal impact is devastating. Ivanka Trump now faces the choice between testifying truthfully and potentially implicating herself and her father in federal crimes, or invoking Fifth Amendment protections in a manner that would likely trigger additional criminal scrutiny from prosecutors who clearly believe they already have substantial evidence. Second, the political implications reach far beyond the Trump family. Republican candidates across the country will face questions about whether they support a political movement where family members allegedly use the presidency to facilitate ongoing criminal activity. Campaign strategists are already describing this as a family values problem that cuts across traditional partisan lines. Finally, looking ahead, the institutional implications are staggering. If Ivanka Trump, who served as a senior White House advisor while allegedly maintaining direct involvement in criminal business activities, faces no consequences, it establishes that proximity to presidential power provides effective immunity from financial crimes. This would fundamentally alter American expectations about public service and personal accountability. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal fallout, this is really about fundamental constitutional principles. The presidency and its associated positions are supposed to represent public service at the highest level. They demand putting national interest above personal financial gain and ensuring that business activities don't compromise official duties or violate federal law. If a former first daughter can allegedly engage in systematic financial fraud while serving as a White House advisor without facing criminal consequences, civilian oversight of government officials is effectively compromised. The implications for the presidency itself would be catastrophic. This scenario is causing sheer panic within Ivanka Trump's legal and business circles. Reports indicate that her legal team held emergency conference calls throughout the weekend to develop a response strategy. Sources familiar with these discussions say the meetings included high-profile defense attorneys Charles Harder, who previously represented Ivanka in defamation cases, and Reed Weingarten, a renowned white-collar defense specialist known for representing high-profile corporate executives. Some lawyers argued for full cooperation with prosecutors, claiming that the documentary evidence makes denial impossible. and that cooperation could potentially result in reduced charges or immunity in exchange for testimony against other family members. Others, led by Weingarten, according to sources, insisted that Fifth Amendment protections provide the only viable defense against what they characterize as politically motivated prosecution designed to pressure Donald Trump's 2024 presidential campaign. The legal strategy sessions reportedly became increasingly contentious as attorneys debated whether Ivanka's interests aligned with those of her father and the broader Trump organization. Sources say several lawyers expressed concern that joint defense agreements could create conflicts of interest if prosecutors offer Ivanka immunity in exchange for testimony about Donald Trump's role in the alleged fraud scheme. The Trump Organization board is fracturing in real time, torn between loyalty to family members and the responsibility to address serious criminal allegations that threaten the entire business empire. Multiple directors have reportedly retained independent legal counsel, suggesting they're preparing to distance themselves from potential criminal liability. Sources familiar with board discussions say at least 3 directors have privately discussed resignation if the criminal charges expand beyond Ivanka to other family members. Emergency board meetings held on January 18th and 19th allegedly focused on potential asset protection strategies, including the possibility of transferring property ownership to shell companies or family trusts to prevent potential government seizure if criminal convictions result in forfeiture orders. Legal experts note that such asset transfers during active criminal investigations could constitute additional obstruction charges. Meanwhile, Ivanka's core supporters and social media followers are expressing fury at what they characterize as persecution of a private citizen who left politics years ago. Posts across Truth Social and Twitter demand congressional investigations into prosecutorial misconduct, with claims that federal authorities are manufacturing evidence to damage Trump's 2024 presidential campaign. The hashtag number Stand With Ivanka began trending on Tuesday evening, generating more than 250,000 posts within 12 hours. Things escalated further when Donald Trump responded with a series of posts from his Mar-a-Lago residence on January 18th. He called the subpoena a continuation of the witch hunt and claimed prosecutors were targeting his daughter to pressure him into abandoning his presidential campaign. The post specifically attacked Manhattan District Attorney Alvin Bragg and Judge Engoron, labeling them as corrupt Democrats who will pay a political price for this persecution. Stay with me. What comes next will completely change how you view the situation. Here's what makes it even more extraordinary. Trump's immediate response to his daughter's federal subpoena was to attack the prosecutors and judge rather than address the substance of the evidence. Instead of expressing confidence in Ivanka's innocence or challenging the authenticity of the documents, the reaction was pure deflection toward familiar political enemies. When your defense strategy focuses on attacking the legal system rather than disputing the evidence, you've essentially conceded that the evidence itself is problematic. Legal experts immediately flagged this defensive posture as potentially damaging to both Donald and Ivanka Trump. Joyce Vance, former federal prosecutor, told CNN that family members who attack prosecutors handling active criminal investigations risk being perceived as engaging in witness intimidation, particularly when the attacks target specific federal officials by name. This goes far beyond a single criminal investigation. It's about whether family members of presidents can engage in systematic financial fraud while serving in official government positions without facing meaningful legal consequences. If there are no criminal charges despite what prosecutors describe as compelling documentary evidence, it signals that political connections provide effective immunity from financial crimes. If this blows your mind, hit that like button right now. This isn't just about the Trump Organization or even the Trump family. It's about whether our justice system applies equally to people who serve in the highest levels of government. If former White House advisors can allegedly commit financial fraud with impunity, it fundamentally changes what Americans should expect from public servants. When federal judges start issuing emergency subpoenas with 10-day deadlines and arrest warrants, we've entered unprecedented territory for family members of former presidents. The precedent this case establishes will determine whether proximity to presidential power provides functional immunity from criminal accountability. If there are no consequences, it sets a dangerous precedent. Future presidential families could engage in criminal business activities while serving in official capacities, knowing that political connections and family loyalty will protect them from legal accountability. Keep a close eye on this story. Ivanka Trump has until January 27th to appear before the grand jury or face immediate arrest under federal warrant. Prosecutors are reportedly preparing additional subpoenas for other family members and Trump Organization executives. And families across America who value accountability and the rule of law are watching closely to see whether our justice system treats powerful political families the same as ordinary citizens. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. A federal judge has given Ivanka Trump exactly 10 days to appear for grand jury testimony regarding her alleged role in systematic financial fraud that prosecutors claim spans nearly a decade. Federal marshals have personally served the subpoena with explicit arrest authority if she fails to comply. Meanwhile, prosecutors are reportedly preparing additional criminal charges that could fundamentally alter the legal landscape for the entire Trump family. This isn't just another news cycle that will fade away. This is a constitutional reckoning unfolding in real time involving the intersection of presidential power, family loyalty, and criminal accountability. What happens over the next 9 days could determine whether family members of presidents are subject to the same legal standards as ordinary American citizens. The evidence is mounting. The subpoena has been served. Now we wait to see if criminal accountability still applies to people who served in the highest levels of American government. The stakes have never been higher. The evidence has never been more direct, and the constitutional crisis involving presidential family members has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.